Under Title IX, what does the term sex mean?
We think it's properly interpreted pursuant to its ordinary traditional definition of biological sex, and I think probably given the time it was enacted, reproductive biology is probably the best way of understanding that.
Thank you.
Justice Sotomayor?
You know, the problem I'm having with what you're doing now is you're doing exactly what Justice Stevens said should be done, and he admitted later in O'Connor that the court roundly rejected that in Caban and Lear. He wanted to do exactly what you said. He said, in dissent, this court should be in analyzing equal protection, contending that if the classification is justified in those cases in which the rule has its most frequent applications, then it doesn't violate equal protection. And then he said the court should presume that the law is entirely valid and require the challenger to demonstrate that its unjust applications are sufficiently numerous and serious to render it invalid. It's exactly what you said we should be doing. So you want us to accept what the dissent did and not what the majority said it was doing in Caban or Major. In BMI, Justice Scalia said the same thing, that taking the majority's logic to its logical conclusion, a single woman who wanted to attend could satisfy the admissions requirement would be enough for an as-applied challenge, and that shouldn't be the law. You're asking the court to adopt views expressed by two minority dissenting judges in this case. We've been doing an awful lot of that lately, but you're smiling because it's true, but you're asking us to adopt an approach that we have rejected as a majority court and accept what dissenters are doing, correct?
With all respect, no. Again, in Caban, nowhere in the majority opinion in Caban did they say this law is reasonable for certain classes of men, but it's not reasonable.
It did exactly. It said it's reasonable for fathers who don't support their children. It won't be reasonable for fathers who don't.
With all respect, Your Honor, it did not. Caban did not uphold that law as applied to any man who hadn't abandoned their child. Now, it is true Lair upheld the law for someone who had abandoned their child, but the reason it upheld the law is because women who abandoned their child.
But the logic of the opinion is that if the reverse had been true, it would have ruled the way it did.
I don't think that's
Counsel,
true, but even if you thought that was, sure.
No, I just have one last question. What's percentage enough? There are 2.8 million transgender people in the United States. That's an awfully big figure. I do understand that in Idaho, this was the first transgender child, but that just happenstance as to location. What makes a subclass meaningful to you? Is it 1%, 5%, 30%, 15%? One is not enough for you, but why?
Well, so I'll say,
when the numbers don't talk about the human beings.
So I'll say a couple of things about that, Your Honor. The first I'll say is if the distinction between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit, 1% surely has to be on the side that's reasonable. But if you don't want to just take the 1% on its own face, I would point your court, you want to focus on majority opinions or opinions for the court. Michael M. rejected a challenge even though that law wouldn't, for infertile couples, either infertile rapists or infertile victims, the justification didn't apply. There are certainly more infertile people.
They did it on a different basis, which had to do with different harms.
No, that's not true, Your Honor.
Well, I can read the decision and tell you.
With all respect, that paragraph, it says, even setting aside the physical differences, it is ludicrous to think we have to exclude infertile children from this rape law. And there are certainly more infertile people than there are trans-identifying individuals who take these drugs and eliminate all their physical advantages. So if we just focus on holdings of this court, we know that this percentage is too small.
Justice Kagan?